Hi, and welcome to this edition of Criminal Justice Natters with me, Ed Johnston. Today, we're joined by a criminal defence lawyer, Maxine Twynam, and we are going to discuss a number of issues that currently exist in the criminal justice system, and some of which have been heightened by COVID. So we're going to look at issues with released under investigation, the disclosure crisis, youth justice, and general justice in the magistrates' courts. So I hope you enjoy, and yeah, let's get to it. Hi, Maxine. Thanks for joining us today. And I really appreciate you taking time out of your day to come and speak to us. What I wanted to start with, we have a lot of students that watch this that are considering careers in various areas of law. So I wondered if you could tell us a little bit about your career and why you chose this particular direction.
Sure. I was always interested in law from a really young age. I think I was sort of under 10. And as a child, I sort of wanted to either be an astronaut or a lawyer. A little bit influenced by LA law and things like Ally McBeal, which is obviously totally unrealistic. But certainly I wanted to be a lawyer from a young age. But in fact, when I was going through secondary school, I was told by a tutor that they didn't think I'd make it as in law because they didn't think my English was good enough in terms of sort of grammar and spelling. So I was a little bit discouraged, but then thankfully I did law A-level, and I had a wonderful teacher who was called Mr. Lodge, and he had only practiced for a year. Actually, he had predominantly taught law A-level, but he just brought it to life and made it really interesting. We used to do mock trials and various things, and that's when my interest started to grow, and I thought, well, I want to pursue a career in law. And I think in many ways often people don't want to go into criminal law because they think there are unsociable hours, the pay isn't very good. You know, if I did sort of something like commercial law, I'd probably earn 4 or 5 times more than what I currently earn, and I'd have pensions and things like that to look forward to when I retire. But I always felt it was like real law, and so I was fortunate enough to gain an opportunity with a firm that specialised in family law. Managed to get a training contract, which I was a bit lucky to obtain, but they were very helpful, and then practiced criminal law pretty much on and off since 2004. I've done some other things as well, working for youth offending team for a project which helped inner city sort of school children and tried to sort of divert them away from the criminal justice system. And I've also worked for the court service advising magistrates for about 18 months, but overall I've been involved in criminal defence from the outset, and currently work in Exeter for a niche firm.
In terms of your role as advising the magistrate, I think a lot of our students kind of don't necessarily understand that advisor role. What was it you had to do for the magistrates, and what was that like on a day-to-day basis?
Yeah, so it was interesting because when I joined, I'd only seen it from one perspective, obviously from a defence perspective, and I didn't appreciate the sort of the work involved, and underestimated how much I needed to know and understand. And predominantly in the magistrates' court, they've recruited internally. So a lot of people who have advised magistrates have worked for the court service for 30, 40 years, and that's fine. But they are all coming up to retirement. So there was a massive sort of recruitment drive, and lots of people joined with different experiences. We had to obviously advise magistrates on law, procedure, in relation to trials, bail hearings, all sorts of things, and also assist people who are unrepresented as well, and make sure that everyone was treated equally, that the system, runs how it should. And so that was interesting to see it from a completely different perspective. But in the end, I've come back to the thing I'm passionate about, which is criminal defence, and in particular helping people who are vulnerable, for various reasons, whether it be mental health, learning disabilities, because of where they live, they maybe not don't have the opportunities and are treated differently to others within the criminal justice system. And so that's why I've come back to criminal defence predominantly.
One more thing on this magistrate's role before we move on.
Yeah, of course.
The assisting the unrepresented defendant, what problems did that? A, was there a lot of them, and B, what problems does the unrepresented defendant face?
Yeah, so you tend to get a lot of people that are unrepresented in cases where obviously it may be traffic cases or cases where they're not going to be entitled to legal aid because they're non-imprisonable offences. So it's going to be difficult for them to get legal aid, or they earn too much to get legal aid, but they can't afford to pay a solicitor or a barrister to represent them. So you tend to get quite a few people, and it's just making sure that they understand the process, because having defended, I knew that a lot of people found it a very daunting experience. You walk into the magistrate's court, you look up, there's 3 individuals sat there and the legal advisor in front, and it can be a very alien environment. And to everyone, it doesn't matter what the charge is, it can have a massive impact on their life, especially say if you've got someone who may be charged with a speeding offence, and if they are found guilty of that offence, or if they plead guilty to it, they may be disqualified because they may have other points on their licence. So there are really significant implications, and it's just making sure that they're treated fairly and they understand the process. I was quite passionate about that, because there is this perception sometimes that people feel it's a police court, but they're not going to get a fair trial or a fair hearing, and it's just making sure that they realise that's not going to be the case. Or certainly when I sat as a legal advisor, I felt that was important, that they realise, I'm not there to judge them. I don't make the decisions. If you're a legal advisor, you're there just to support the magistrates and make sure they understand the law and do it properly.
And what was the volume of unrepresented defendants during your period there? Was it the majority or the minority?
It really varied. But, we were dealing with a lot of unrepresented people. It wasn't just sort of on the odd occasion. There were quite a few, because with the changes to legal aid over the years, not everyone is eligible. And as I said, they can't always afford to pay someone to represent them.
Okay, thank you. In terms of sort of moving forward to how the criminal justice system looks today, obviously we're in the middle and still in the global pandemic, COVID-19. What's the impact of the pandemic for defence lawyers in particular?
Well, I think for everyone involved, it like in lots of different industries or fields, it's had a massive impact. So police station wise, we've had to really change how we work. From different areas deal with things in different ways. Often different officers deal with things in different ways. But I always think of it like this: the police station is the most important part of the process in many ways, and if you get that wrong, the whole case can fall down on that. So it's really important to get it right. And so predominantly, certainly during the height of the pandemic, we were advising people remotely. So that might be by telephone. They would often be in their cell, the accused. Sometimes it would be via an intercom system, where you'd actually have to be shouting down your phone so that they could hear you. And sometimes that individual has been in a police station before, maybe, and they've had your firm before, so there's a relationship that you've built up over years. But sometimes it's someone who's never been in a police station before, who may have mental health difficulties, learning difficulties, English isn't their first language, or they're a juvenile, and that's been really challenging. And I always think of the police station, it's like a game of chess. It's quite complicated and strategic often. And in the pandemic, it's like doing a police station remotely. It's like playing chess but blindfolded. So you're not physically there, and you're trying to do the best for your client, and you're also wanting to make sure that they're protected as well with the pandemic. So we've had to do a lot more, or certainly I can't speak for everyone, prepared statements. So we've also, some officers have accepted those, quite a few have, and that's been fine. But in other occasions, they've still insisted on interviewing someone, and then it's, whether your client wants to take that risk, because they'd be going into a room. Certainly throughout the height of the pandemic, they were going into a room which isn't ventilated, often with 2 officers, maybe even an appropriate adult or an interpreter, and they wouldn't be wearing masks. So, it's making sure that they're protected, because I can be doing a police station remotely, I'm safe, but I'm also conscious that I want my client to be safe as well.
Do you think the sort of advent of sort of remote attendance at the police station, sort of when we come out of COVID and things get back to normal, do you think remote attendance would be here to stay? Is that something you would want as a defence lawyer?
I certainly think that well, I hope it won't be. There's been benefit, it's a difficult one. I'm sure everyone will have different opinions who are involved in the criminal justice system. But I would prefer to be there. I would prefer to support my client. I mean, if you're doing a remote interview, and I have done some, you can't pick up on how your client is coping in a room with maybe 1 or 2 officers sat opposite them. So, it might be that they're feeling very distressed, and normally you'd encourage the interview stop so that you could speak to them, make sure they're okay, because as we know, it's an intense and daunting process, and you're not there to support them. And it's also been incredibly tricky. I've had cases with interpreters where, the interpreter has been remote as well. So we're all remote, and that's been really tricky, because you want to make sure that the client, gets the same result they would get whether you're there or not.
Yeah.
And I do feel in the future we are going to have to be going in, really.
In terms of, you mentioned that staying with remote attendance, you mentioned that sometimes it's telephone legal advice, but you gave the example of the Intercom.
Yeah.
So that was at the police station.
Correct. So it has varied, and I think different parts of the country deal with things in different ways. So I'm based in Devon in Cornwall. So in one of the police stations in Devon, they have a phone which they take to someone who's in a cell, and you speak to them in that way. In another police station, you might have to do it via an intercom, which means, as I said, you're shouting down often your phone, and they have to, they're in their cell. And if they've never been in that position before, you obviously have to build up a rapport with them in quite an unusual situation. And so that's been a real challenge, to make them feel that they are going to get the service that they not only need but deserve.
And in terms of the intercom, how do you go about securing that when you have your sort of client consultation before the interview, that that nobody else is listening?
Well, it's difficult. I've seen a lot of other lawyers say that they have concerns that people, have listened in. Where I'm based, I haven't had the same concerns. Although I did have a case where it was via an interpreter, and they were in a different part of they were in Wales, I think, and I was in Bristol. And, we were having a conversation, and the client was going to give an account in an interview. But then a few months down the line, I had another similar case, and the officer in that case said to me, well, I'm a little bit concerned because I'd have to wait outside the room whilst you talk to them in a three-way conversation, which means I could potentially hear what's going on. So that is obviously concerning. Obviously, everything we discuss is confidential, but it might make a client feel very nervous and apprehensive of telling you exactly what the position is, because they may feel, well, how do I know that you're genuinely a defence solicitor and that people aren't listening in? And they might not tell you exactly what happened in a truthful way that you can then give them the proper advice. So you have to trust that hasn't happened, but it's far from ideal.
Yeah, thank you, Maxine. In terms of just one last thing on COVID, we constantly hear about the backlog of cases that the criminal justice system is facing. Obviously, this existed before COVID-19. But again, how has the pandemic sort of made this worse and slowed everything down? And what can we do to solve it?
Sure. I actually have to look to a piece of paper. I looked it up a little bit to try and get some information, some statistics for everyone. And my understanding, so in the magistrates court pre-COVID, there was, I think it was in March 2020, there were 395,978 cases that were outstanding. And that, as of the April 2021, was 463,215. And pre-COVID, there was 39,000 Crown Court cases outstanding. And as of April 2021, there is 57,000 to 58,000 cases outstanding. And yes, it is really concerning. Obviously, when the pandemic hit the criminal justice system, we were in crisis anyway. And no one, as we all know, was expecting it to happen. So they had to bring forward dealing with cases remotely, but by a system called CVP that wasn't, planned to come out during the pandemic, but they had to do that. And for a period of time, they stopped all Crown Court trials, all magistrates trials, and just dealt with sort of urgent cases. And that has increased the backlog and caused problems. What has been interesting is different areas, again, deal with things in different ways. Where I'm based in Exeter, they've been really good at making sure that people can deal with things remotely if they can. But in other parts of the country, that hasn't happened. I certainly know I was, during the height of the pandemic, forced to go somewhere which had massive problems with COVID to deal with a hearing that I could have dealt with virtually. And that was really disappointing. But certainly where I'm based, thankfully, that they've been really careful and they've made sure that people, wherever they're based, if they can appear on the video link. They've been supportive.
Okay, thank you. And again, in order to shift the backlog,
Sorry, you did ask that, yeah. It's going to be really difficult because we've had cuts and cuts and cuts in the system. Court closures, police station closures, budget cuts to the CPS, cuts to the legal aid budget for years and years and years. And we were always playing catch up. Somewhere I read that they feel it's going to take 10 years to sort of clear the backlog and to recover from the pandemic. And I don't really know what the answer is, because you've got the resources you've got and they're already overstretched. I see things, where they say, well, we've recruited loads of officers during this time, that will solve the problem. But actually, and we can be tough on crime, but actually the reality is you may have recruited officers to replace other officers that had a vast amount of experience. And you can't just overnight do your training and expect an officer to be up to that level in terms of, being able to deal with all these cases. Yeah. So it's difficult to know what the answer is in truth.
Do you think that in order to attract, graduates into the criminal defence profession, that we're going to need to see an increase in legal aid rates to make it a more attractive proposition? I mean, I've been teaching 9 years, and I can probably I wouldn't fill both my hands with the amount of students who have gone into crime, despite the fact that they've taken, 4 crime modules over 3 years that I've taught them on. They go in a different way when the money starts to talk.
Yeah, that's the thing. We really want people to come and join us, because it is as I said before, right at the beginning, it's real law. You can make a difference. I know that's a bit of a cliche, and some people say that isn't true, but most people who want to become a lawyer, but they either want to do it in many ways for 2 reasons. Like you said, either they want to go, they're interested in criminal law and criminal justice when they're doing their degree or further education, but they know that they're not going to make much money, and money is a big motive for them, and that's perfectly understandable. But if you really want to make a difference and do real law, then I hope people will come into the criminal justice system, because it is concerning. It's an aging profession, and we need more and more people to come in. And as we all know, money isn't everything. It's about satisfaction, and I come home most days, and some days are very stressful and some less, but I feel that hopefully on most days I've made a difference to someone's life and helped them.
Okay. Just moving on to a couple of things we spoke about last week before we had this chat. RUI, released under investigation. Obviously, a few years ago there was this shift from bail to releasing suspects under investigation. Has it worked?
No, not in my view. No. The idea, as you know, was that too many people were on police bail for too long. And, I can remember one case where someone was accused of rape and they were on police bail for 2 years. And at the end of that 2 years, despite me chasing the officer and actually writing to the prosecution and trying to see whether they could help, the police make a decision sooner rather than later. At the end of that, the police chose to take no further action against my client. But during that period, his mental health declined, and I remember, him being very suicidal at times. And so they wanted to change it, and like you said, they changed it so that there are time limits when it comes to police bail. And of course, then what happens is that most people now are released under investigation, and in fact, then you lose track. So people don't have obviously bail conditions if they're released under investigation. You have some serious allegations where people have been released under investigation, including murder, attempt murder, rape, and the case sort of goes on forever, because one presumes that if you're an officer, I don't know, but you come in for your shift, you're going to deal with the detainees that are in the police station then and there, and that work gets put to the back, and it's really daunting. And for those accused, it's unbelievable, because they are waiting. There's no sort of they will often ring us. Sometimes we lose touch, but they will just want to know what's happening. Understandably, I saw one of the interviews that you did with the charity, the defendant.
Yeah.
Charity, and it's right that the idea is that a lot of our work sometimes is just trying to reassure people and give them realistic expectations.
Yeah. Go on, sorry.
I was going to say, I look back at my police station since May last year. I think I've done around 100, and for me, about 20% of those have been released under investigation around. So if you think of that nationally, how many lawyers in the deal with criminal defence, how many duty solicitors as well there are, that's quite frightening, really. And
I suppose with released under investigation, it offers no protection to the complainants either, in terms of there's no conditions or time limit. So this drags on for them as well. It's not just the defendant or the suspect, that suffers this prolonged agony. It's the complainant as well.
Yeah, absolutely. And the difficulty is this, that if you think, so you're released on investigation and that case gets put, behind other cases, and it can take several months or even years to find out what's going to happen. And then if it gets into the court system, they're behind all the other cases that we know exist. So, you know, do people lose interest? Do people then feel, well, you know, what is really going on with the criminal justice system? You know, they say magistrates is speedy justice, but, you know, if there's this sort of backlog, is it really speedy justice? So, yeah, it is challenging. And I tried to look up and I couldn't find it. Maybe it was just me, but how many people, just out of interest at the moment, are released under investigation? I tried to see if there was any statistics and I couldn't find any. But I'd be interested to know nationally how many people are currently released under investigation.
Yeah, I would imagine it would be an extremely high number. And as you say as well, the severity of offence that you're released under investigation for. I mean, you think about domestic violence or assault, where there might be some form of intimidation or retribution being meted out. There seems to be very little protection for complainants with released under investigation.
What you find increasingly, say with domestic violence allegations, is that the police may release someone under investigation, but they'll go to the court and try and make an application for a domestic violence protection order, which only will last for 28 days, but they tend to do it that way often, certainly where I'm based, as an alternative. So there's a degree of protection. But regardless of whether someone committed an offence or didn't commit an offence, anyone involved in that incident, whether they're a witness, complainant, victim, accused, you know, it's really, really worrying that these cases are just, you know, they just go on forever pretty much. And you often will try and chase officers now and again to find out what's happening. And often they say, oh, it's still under investigation. And you wonder what's been done in that interim. But I do appreciate that there's lots of pressures, you know, on those officers, and they haven't got the resources that they need. Because gone are the days that they had the specialist police teams where you'd have, you know, the robbery squad, the burglary squad, who would then be focused on resolving those sort of cases. Yeah.
And all of this is just adding to the backlog anyway.
Absolutely.
So there doesn't seem to be any sort of fixed end to this backlog either. The whole system seems to be mired with issues. And another issue I wanted to talk about, and it's pretty much my primary research area with work, is disclosure.
Yeah.
So in your opinion, how does the disclosure regime work?
Well, it's difficult, isn't it? Because if you're in the magistrate's court, you're obviously only entitled initially to certain things, the what we call the IDPC, and that varies on the area you practice, so, or where you practice in the country. So, you know, sometimes you get better disclosure prior to the first hearing, or on the day of the first hearing, than in other places. Sometimes, you know, the police will notify the powers that be whether they think it's an anticipated guilty plea or not guilty plea, and that can reflect what sort of disclosure you will get prior to that hearing, or as I said, on the day of the hearing. And so it varies. Sometimes you'll get statements, witness statements and exhibits. Sometimes you just get a case summary, and a summary of what your client may or may not have said in interview, which sometimes is accurate and often isn't. And then, you know, if the case goes off, as I said, for say a trial, then dates may be set, but often you're finding up until the day of the trial you haven't got the disclosure you need. They haven't complied, the prosecution, with the initial duty of disclosure, despite you chasing them and informing the court they haven't done that.
And what would be the court's reaction to that if the prosecution hasn't complied? Do you get your adjournment so you can receive the disclosure and advise your client appropriately? Or
it varies, again, depending on where you are. Sometimes, you know, they might sort it out on the morning of the trial and the case is put back and you're expected to sort of crack on as soon as possible because witnesses are there and, you know, and so on. Other times, if you haven't got everything, then the court appreciate that and it goes off. And the court may say they're disappointed with the prosecution, but the poor prosecutor who's there on the day explaining the position, it's not their fault. And people say, well, they're under-resourced and so on. Likewise, when you get to the Crown Court, it varies again, because at least with the Crown Court, you've got a timetable and you've got different stages and, for when disclosure is meant to take place and to happen, and you can list a case for mention if things aren't happening, and the Crown Court are quite hot on that. But you do find cases, and we know there are examples where you can be halfway through a trial and all of a sudden, information comes out that you should have really had before, and it can make a real difference to a case. And so, it is really concerning. Often, the idea is people think, well, your client, especially in the magistrates, should know whether they're guilty or not. Yeah. They should know if they were there or not, and that's not the case. You're innocent till proven guilty, and I want to see what evidence you have.
And in terms of if the prosecution doesn't comply with any disclosure or anything, you get it on the day. If you weren't to comply with your duties of disclosure, is there a different tone from the court if it's your fault opposed to the prosecution's fault?
I mean, it depends. Yes, I would say. I mean, my example is that we're all meant to be, as you know, treated equally. I mean, that's the whole point of the criminal procedure rules, and that is certainly the point. When it comes to adjournments of cases like Picton, where they set out that it would be treated fairly and equally, it can be difficult. On the flip side, not disclosure, but I'll give you an example during the pandemic, which I think we discussed previously, but I did think of a better example. I had a case where someone was shielding.
Yeah.
They didn't have a solicitor when they came to court, and they asked for the duty, and that's how I picked up the case. And I said, well, you shouldn't be here because you're shielding. And they had received a notification from the court, because they had told the court they were shielding, but they either had to provide proof of that, or the court would issue a warrant if they didn't attend. And they didn't have the means or facility to sort of do that, because, as we all know, if you're shielding, you had to remain inside, so you couldn't go to the post office. They didn't have anyone that could do that. They didn't have a scanner or a computer to email across proof. So they then put themselves at serious risk. On the flip side, I had a situation where someone had a trial, and we were told that the witness was either shielding or I can't remember, or had, or the complainant, I should say, or was caring for someone shielding. No proof whatsoever, but the court gave them the benefit of the doubt, and that trial was vacated. And then when we had the second date for the trial, that person didn't turn up. So, that's an example during the pandemic. I realise it's not disclosure related, but you shouldn't be treated differently. And that's an example where I feel parties were.
Yeah, and to go back to the criminal procedure rules, the idea, dealing with cases justly is the overriding objective, and part of that definition of justly is dealing with the defence and prosecution fairly and equally. And clearly there's some sort of disparity there.
There is, and I'm quite fortunate in the place where I work, where as I said to you at the beginning, the court's been very accommodating where I practice when it comes to the COVID pandemic. But at the end of the day, these sort of things do happen, and there are disclosure issues, and someone who is, as we all know, accused of an offence, whether it's something that is imprisonable or non-imprisonable, whether it's a magistrate's case or it's murder at the Crown Court, it can have a massive impact on them, and it's got to be done properly, and the rules are there for a reason, and I think they should be enforced more.
In terms of that enforcement, just before we move on to the youth justice stuff, in terms of that enforcement, What do you think? What sanctions do you think the court could issue to the prosecution? You know, there's various sanctions for the defence and the defendant in particular, but what can we do to ensure this public body, the Crown Prosecution Service, comply with these rules?
Well, as I said, I feel for them, because I have a lot of respect for a lot of people that work at the prosecution, and I, you know, we've all got a job to do, and I do feel it's difficult for them. Often, you know, the person, as I said, that stands up there and has to explain why things haven't been done, it is the full person, the guy, you know, that it's not their fault, and they're under resourced, and as we talked about before, we've had lots of budget cuts, but I think we have to get even tougher. You know, the courts have to be tougher, because it isn't good enough. And you know, when I first started practice, we used to have probably too many hearings in many ways, but we used to have pre-trial reviews more. Yeah. You know, these sort of things were ironed out in the magistrates court at an earlier stage, so that we didn't get to the day of trial and things weren't ready. Yeah. And so I think, you know, maybe that's something we need to reconsider. Or maybe it doesn't have to be an actual hearing, but we have a conversation, remote conversation, a three-way conversation, because certainly the Crown Court are able, you know, do that more and more, and there's a lot of dialogue that goes between all parties. So I just feel the Magistrates Court maybe needs to do that more and go back to what they used to do a little bit.
Yeah, if of course with all these closures there would be space to hear the remote hearings would be a good idea to tidy that up, to make sure everyone's ready for the day of trial, and then start clearing the backlog, and this speedy justice idea can play out.
Absolutely.
Thank you. You mentioned previously that you worked with youth justice and youth offending, and I know this is something that you wanted to talk about today. Go ahead.
Well, no, I worked in a project, in a city project with youth offending team, that helped young people, vulnerable young people who were on the verge of sort of getting involved in the criminal justice system, and provide them with various support. And I certainly think preventive work is key. When I first started, you know, you'd have young people that were charged with what I consider quite petty offences, who were maybe in the care system. You know, they, I don't know, caused criminal damage to a tile, and they were 12 and they'd be charged or whatever. Mm-hmm. And certainly that now people are trying to divert people away from the criminal justice system, and there's a lot of support available. But I certainly feel that more needs to be done with young people at a much earlier stage, and the organisations that can make a real difference need that support.
Is this something that's been reduced in terms of budgetary cuts over the last 10 years or so? Is there less of these sort of diversionary methods?
Well, I certainly think that there's been a lot of, you'll see on the news, you know, all these sort of community centres are often, their funding's been cut, and, you know, projects, they've had their resources and funding cut. And having worked in a project which wanted to make, you know, where we wanted to make a real difference, you know, a lot of these people who are working in the heart of the community, you know, can make a real difference. And they can help people who are often exploited from a very young age, and often, you know, need a lot of support. And it's really something that I think needs to change, because no one wants, as we all know, someone who is young to have a criminal, you know, record or to be in the youth court. They want them to get the support they need.
And in your experience of this, on the whole, did this work? Did this divert the young person from future offending?
That's hard to say, because yes and no. Sometimes, you know, someone's going to go down a certain path, and then there's not a lot people can do. But I certainly think it can make a real difference. And youth offending team have a lot of resources, but certainly when I first started, you know, doing youth court work, they had different departments within youth offending team. I don't know if that's changed now, but I get the impression they're sort of involved in lots of things, but certainly I think youth workers, we underappreciate the difference they can make, and underestimate the difference they can make to some young person's life. And then there's a knock-on effect because it's generational, as we all know sometimes.
Okay. One final thing on the sort of youth justice in England and Wales. I assume as well, COVID has had a massive impact on cases that are going through the youth court. Is that anything you would have any experience or thoughts on?
Well, the only concern I have is you are getting situations, as we know, where because of the pandemic, more and more people are being released under investigation, and it can often mean that they started off, they may have allegedly committed an offence, or an incident may have taken place when they were juvenile, and then by the time it gets to court, they're an adult, and they have to be, you have to take into account the age they were when they committed the offence, and so on, if they are guilty of the offence, but there can be significant sort of implications because there's different types of sentences, and also, like we talked about before, having something hanging over you when you're a juvenile into adulthood, it isn't right, and we need to deal with that.
So again, it's just COVID's made this worse, and the outcomes for youth offenders, if you're tried as an adult, would be worse than if you were tried earlier as a youngster. Is that correct?
It would be different in so much of the sentencing options are different. So, for instance, if you're a youth and you plead guilty to an offence, and it's your first time, there are two options. There are referral order or detention training order, which is equivalent of youth custody. And then obviously when you get to an adult, they will take into account, if you plead guilty to something or are found guilty of an offence, what age you were at the time. So they have to take that into account. But the sentencing options are different. On the flip side, it could work in someone's favour, because you can have a situation where an offence would normally be dealt with in the youth court, where if that person was an adult, they could either choose to go have their case heard at the Crown Court, or it would automatically be a case that was sent to the Crown Court. And so in some ways that could be beneficial. But I do think that there is this, with the backlog, there is an increased risk that these individuals, that someone, as I said, accused as a juvenile of something, has to have this hanging over into adulthood. It is not a fair system, and we need to change that and get on top of that.
Thank you, Maxine. I've got one final question for you. It's a real tough one. If you could pick one element of the criminal justice system, fix it completely so it works perfectly, what element would that be?
That is a very good question and a tough question. And I'm sure lots of people have different answers to this. But I think for me, it would be that everyone is treated just the same, regardless of whether of their ethnicity, of their sex, of their disability they may have, or their religious beliefs. That everyone is treated equally, and it's not just something that's in writing, that's set in stone, in manuals or in the rule book, but but is actually something that happens in practice. Because to me, it shouldn't make a difference. Everyone is innocent until proven guilty, and it shouldn't make a difference which part of the country you live, and as I said, what ethnicity you are and what disabilities you may or may not have. It shouldn't make, the outcome should be the same, and that's not I do this sort of approach, but I think that's a really important thing. If I can make one change.
And do you think these elements, gender, race, religion, beliefs, do you think they do actually, they are different between different people?
Yeah, 100%. Yes. And I think the criminal justice system has had issues, where over the years, and that ranges from police with stop and search, or all the way up to how people are treated within the criminal justice system and their experiences. And we're now in 2021. We've just been through the biggest pandemic one of the biggest crises ever that we've experienced, and this is an opportunity where we need to change things, and people need to look at things differently, I think. And as I said, it's all well and good having diversity training and having this idea that people tick certain boxes to say yes, they've read this article or done this little course, but it's actually in practice has to change.
Thank you, Maxine. That was very interesting. Covered a lot of ground there, and I want to thank you for your time.
No, not at all. Thank you for taking the time to talk to me.
Thank you, Maxine. That was brilliant. Thank you.
Problem. Take care.
I'd like to thank Maxine for her time today in coming in and talking to us about all of those issues. If you have any questions, please feel free to use the comments or to get in touch. As ever, I'd like to thank our supporters of the show. It can't be done without all of your help, so I'd like to thank Joe Doherty, Donna Jenkins, Lucy Green, Claire Malone, Ian Robbins, Elise Goff, Michael Saw, Pad Ryan, and Wolf Ryan. Thank you very much. Until next time, bye-bye.